Brothers and sisters, welcome. I'm pro-life leader Frank Pavone of Pro-Life Vote and Priests for Life, and welcome to another episode in our series, Fighting the Abortion Ballot Initiatives. We are talking about ballot initiatives that would force an invented fake right to abortion into state constitutions in Arizona, Colorado, and Florida, in Maryland, Missouri, and Montana, in Nebraska, Nevada, and New York, and South Dakota. Those are the 10 states, and you can go to stateballotmeasures.org to get information about all these 10 states and where these battles stand right now, what the pro-life groups are saying, what the pro-abortion groups are saying, and also what you can do about it. So today, in this episode, we're going to start to look at the specific language in some of these ballot measures and show you how dangerous this language is. And we're going to do that with the help of a legal expert, a constitutional attorney, a man that we've known for many, many years and have worked with in the pro-life arena. His name is Allan Parker. He heads up the Justice Foundation. You'll be hearing in a moment a conversation I had with him where we explored the language, and I asked him to comment on some of the ways in which this language would be interpreted by the courts. Because remember, we're not talking about ordinary conversational language when we look at these ballot measures. We're talking about legal language, and legal language is interpreted according to legal principles. And you can get a very clear idea of how courts are going to handle it. How? By precedent, by previous court decisions. You can get a very clear idea about how the abortion proponents are going to handle certain language or use that language as a basis for challenging pro-life laws. Why? Because we're not doing this in a vacuum. We've got decades of experience. So you'll see in my conversation with Allan, I refer to some of that experience, what we've battled through before, and we're going to see how this language, for example, we're going to look at a few different arenas, three in particular. One, how this impacts parental rights, because this is a danger with all 10 of these amendments. We're going to look at how this influences things like clinic safety regulations. And we're going to look at the interpretation of health and how the language in these amendments essentially, no matter what limit the amendment might seem to put on abortion, it's essentially talking about open-ended abortion throughout pregnancy and until birth. So I look forward now to sharing with you my conversation with pro-life attorney and legal expert Allan Parker to help you understand what is at stake with these ballot measures. Well, brothers and sisters, we're delighted to have our friend and colleague, Allan Parker, pro-life attorney from Texas. Allan, you head up the Justice Foundation, which is doing tremendous national work and has for many years. You represented Norma McCorvey and Sandra Cano, the Jane Roe and Mary Doe of the Roe v. Wade and Doe v. Bolton decisions. You were trained in law school there in Texas, and you have been a professor of law. And you really bring an understanding of the Constitution to the abortion issue, which is so crucial. So we welcome you here on this special series about the abortion amendments to shed some legal expertise and constitutional insight into what we're dealing with here. So thanks so much for coming on to the program.
Thank you for having me on. And I did represent Sandra and Norma in their legal efforts to reverse their own cases, because both of those ladies said it was wrong what the court did in our name. And thank God that right now the court has reversed Roe v. Wade in this United States.
It's such a victory. And, it's both of them passed on. I mean, but both of them were friends of both of us. And they both passed on before seeing that beautiful day happen. They saw it from heaven, of course. But they both prayed and longed for that day to happen. And really in many ways laid the groundwork for it. So thank you for being the kind of help and support to them that you have been. So we are dealing, as our viewers know, we've been going through on these episodes with 10 different states that have these ballot measures: Arizona, Colorado, and Florida, Maryland, Missouri, and Montana, Nebraska, Nevada, and New York, and South Dakota. And, you and I are involved in efforts to help across the country. All of these measures, they're worded slightly differently, but they all end up saying essentially the same thing. There's a right to abortion, and government can't limit it or interfere with it. So they're trying to put this in the state constitutions. I wanted to explore with you some of the language and some of the legal implications of the language that are in these amendments, because one of the things we've been sounding the alarm about, we being the entire pro-life movement, is that these amendments accomplish destructively much more than the language would lead you to believe at first glance. And the problem here is that many people are going to go into the voting booth, or they're going to get their ballot, they're going to read it for the first time, it's going to sound pretty good. And what kind of, legal or constitutional training do they have to be able to know what this language really implies? So let me start with the question of parental rights. This is a big concern that, and this has been a big battle in the abortion issue. It's one thing to say abortion is legal, but once you say that, okay, so if a minor is going to get an abortion, what role do her parents have? And most of the states have some kind of parental involvement law, whether that is that the parent, one or both, have to be notified, or whether that is that one or both need to actually consent before the abortion is performed. Okay, so with that as a background, let me just read, for example, Arizona's amendment, Prop 139 as it's called, says every individual has a fundamental right to abortion. In Maryland, question 1 says every person as a central component of an individual's rights to liberty and equality has the fundamental right to reproductive freedom. Okay. Go over to Missouri. Amendment 3 says the government shall not deny or infringe upon a person's fundamental right to reproductive freedom. Head over to Nebraska. Their right to abortion initiative says all persons shall have a fundamental right to abortion. And then as a final example, by no means exhaustive, Nevada, it's called question 6 over there, all individuals shall have a fundamental right to abortion. So my question for you, Allan, is it legally significant? And what are the implications of the fact that the language here is talking about individuals and persons? It's not using the word adults. And it's not saying anything about parents or minors. Legally, what does that mean?
This is actually part of the left's strategy to not only destroy the child in the womb by killing the child through abortion, the intentional destruction of human life, a member of our species, Homo sapiens, but it actually is an attempt to destroy childhood. They want to destroy childhood so that every child basically has the right to sexual pleasure rights and to choose their own church or not church. They want them to have the rights of an adult as soon as they are even able to speak, the right to transition from one sex to another while they're still a child. So this is part of that. Now, it also is setting it up against the other fundamental right that's already in the Constitution. That's the right of parents to direct the upbringing and education of their own child. That's been in the Constitution at least since 1993, because in 1923, excuse me, when the Supreme Court recognized it. But they said this is a natural right. We already have this, and governments are instituted to protect our fundamental right to direct the upbringing and education of our children. Upbringing means care. As you said in your introduction, most of the time, a doctor cannot perform a surgery on your child or give them a medicine that produces the death of another human being, which is what the abortion pill does, without the parent's permission. And here's one reason why that's so important. One of the women, by the way, I've represented thousands and thousands of women hurt by abortion. And one of the women that was hurt by abortion was a mother who found out her daughter had an abortion when she got admitted to the mental hospital because she'd been trying to commit suicide, and it came out that she'd had an abortion. So mom and dad had to pay the hospital bills for the child's mental care, but they weren't told about the abortion beforehand. And all of these ballot initiatives will most likely and are intended to destroy the parents' fundamental right to direct the upbringing and education and care of their usually teenage daughter who hasn't yet gotten her own rights because she's not 18 years old. So you're right. It's a terrible destruction of the family relationship. And most people don't think, oh, now the state and a doctor who's making money off of the killing of my grandchild will also now have the right to do it without either my consent or even notification. And most states that have considered it say parents should be involved in a minor having an abortion. And it is a terribly devastating thing for minors. I represent thousands of women hurt by abortion, and many of them had abortions when they were minors. And also, minors are more susceptible to being forced to have an abortion by someone else, perhaps their own parents or the boy who's gotten her pregnant or the man who's gotten her pregnant. In many circumstances, older men like to have sex with teenagers. And then if they can take her, she signs a form saying, I've given permission. Nobody knows that the abuse is continuing. In fact, the incest exception, which some people think we have to have rape and incest, what the incest exception actually allows is for incest to continue. Incest by its nature is a family member who's trying to hide it. If he takes her to an abortion clinic, she gets an abortion, abuse can occur over and over again. And but if the baby is born, an examination and DNA testing will prove who the father is, and the abusive man should go to jail.
Thank you for that. Parents, beware of these amendments. A child can say, oh, I have the constitutional right now as an individual to have an abortion. No mention of parents at all. Let me give you, Allan, another concern here that many people are raising about these amendments. And that is, it's one thing people understand if an amendment says, okay, the state cannot prohibit abortion. So in states where unborn have protections already of their lives, these amendments would take away their protection. In places where abortion is banned, it would now be permitted thanks to these amendments. However, the language of these amendments doesn't stop there. It doesn't just say the state may not prohibit abortion. Let me read again some of the examples. Nevada's question 6 says, the right established by this section, that is the right to abortion, shall not be denied, burdened, or infringed upon. Okay, so now we see these additional words. Montana, CI 128, their amendment says this: in no circumstance shall the government deny or burden access to abortion. Missouri Amendment 3, the right to reproductive freedom shall not be denied, interfered with, delayed, or otherwise restricted. And Florida's Amendment 4 says no law shall prohibit, penalize, delay, or restrict abortion. So we're concerned about what all these other words might be opening the door to in terms of what the state can no longer do, either by legislation, executive action, judicial decisions, and so forth, because everything has to obviously follow the Constitution. I want to read here, before I get your comments, from the grand jury report of the Gosnell case. We remember back in 2011, from 2011 to 2013, this Gosnell case out of Philadelphia, this really, really corrupt abortionist got a lot of attention, and his place was raided, and it was a house of horrors. There was a movie made about it. And the grand jury said this. Let me read a sentence or two here. Under Governor Robert Casey, the department inspected abortion facilities annually in Pennsylvania. Yet when Governor Tom Ridge came in, the attorneys, now Robert Casey was pro-life, Tom Ridge was pro-abortion. Tom Ridge came in, the attorneys interpreted the same regulations that had permitted annual inspections for years to no longer authorize those inspections. Then only complaint-driven inspections supposedly were authorized. Stolosky, who was a Pennsylvania Department of Health official, said that the policy during Governor Ridge's administration was motivated by a desire to be, and this is in quotes, putting a barrier up to women seeking abortions. So the thought being, because they didn't want there to be a barrier to abortion, abortion was legal, but because they didn't want there to be a barrier, they stopped inspecting the clinics. Okay, one other example, the ACLU had a brief in a case that went all the way to the Supreme Court, as you're very familiar with, the June medical case. This was back in 2020. And this was about a Louisiana law to require abortionists to have hospital admitting privileges, okay? So they're trying to ensure the safety of the women going for abortions. And the ACLU argued, they said, we argue that the Louisiana law now before the court is just as medically unnecessary and just as harmful as the Texas law that had also been struck down. It would force most abortion clinics in the state to close their doors and block people from accessing abortion. Judges around the country have found that similar laws would shutter abortion clinics and prevent people from being able to access an abortion. So I bring this up to illustrate it's not just about prohibiting abortion, but the other side is using this kind of language, you shall not burden an abortion or delay or interfere with in any way, same kind of language we see in these amendments. They've used it before to strike down even things as reasonable as making sure you got a qualified doctor or a safe clinic. Allan, what's your legal perspective, therefore, on this broad, undefined kind of language in these amendments that would seem to lead to striking down all kinds of reasonable regulation?
The goal of all this language in all these ballot initiatives is to get unlimited, unregulated abortion. Think about that. Unlimited by the age of the baby. You can have an abortion up to the moment of birth. Because if she's 36, 38 weeks pregnant, but still hadn't had the baby, and you say no abortion then, well, you're delaying it. You're putting a burden on her. Think of that across America, unlimited, unregulated abortion. And by unregulated, you couldn't have a hospital rule that says if you're going to, or a state rule that if you're going to perform abortions, which particularly surgical abortions can puncture a woman's uterus, can leave her sterile, can cause excessive bleeding and hemorrhaging. And most doctors, if you perform something outside the hospital that can lead to hospital admission, they want to be admitted by hospitals so they can take care of their patients. That's a high-level, loving standard of care. It's normally professionalism, but it was struck down by the courts who said that limits ability to do abortions because sometimes abortionists can't get hospital admitting privileges. So we don't treat them like regular doctors even. Another simple thing that was struck down under the old rules was viewing a sonogram. For example, if you break your arm and you go to the doctor, most of the time a doctor's going to show you, well, this is the x-ray, here's where it's broken, we're going to set that bone or we're going to go in and do some surgery and fix it. But abortionists don't want women to see that it's a living human being. And again, I represent thousands of women. They're told things like it's just a mass of tissue. Well, that's a misleading lie. We're a mass of tissue, but we're so much more than that. That's why we protect humans and say killing them is murder. It's not murder a cow, but it's murder a human. So anyway, they want unlimited. And the sonogram laws that normal practice would be, because the sonogram has to be done by the doctor to see whether there's one or two babies in there, how many he needs to make sure when he counts the body parts, did he get everything, or the woman could die from sepsis. Sonogram laws would be struck down. Waiting periods, for very serious decisions we often put waiting periods in there. Here's the information. Now, this is going to change your life forever because, as the women tell me, once you kill that baby, you never forget what you've done. One of the ladies said it to me this way. The abortion lady told her, 10 minutes, you'll never have to think about it again. And she said, that lady lied to me. There's not a day go by I don't think about it. You think about it. And all of the states now have better ways to help women than abortion, but the abortion industry doesn't talk about them. And that's the safe haven law in every state, where a woman can simply release her baby, walk out of the hospital with the baby, or surrender it at a hospital or fire station within a certain period of time after birth, and be free of parenting without killing the child and hurting herself. So no restriction of abortion would be allowed at all under these ballot initiatives, as they're so vaguely and deceptively worded.
The deception, for example, if someone went into the ballot box or they looked at their ballot and they said, are you in favor of an amendment that would take away health and safety regulations from abortion clinics? I don't see that passing anywhere.
No.
Except that the language we just read and the examples we gave and the further explanation that you gave could very well lead exactly to that these clinics who would now have, many reasonable health and safety measures, although the pro-abortion groups always oppose us when we introduce such legislation for health and safety. But the people are not being told this. They're not voting up and down on, are we going to remove clinic regulations? Or they're not even being told explicitly, are we going to remove parental rights? And this is where the question of honesty comes in. It's one thing to say, how many people you think are pro-choice, how many are pro-life. But it's a question of honesty. And I know in Missouri, one of the battles that has surrounded that amendment proposal has been precisely the question of, shouldn't the voters be told what existing pro-life laws, because Missouri has a lot of pro-life laws, as a lot of other states do, shouldn't the voters be told before they vote for this amendment which existing policies are likely to be repealed as a result? And this has been a big battle in Missouri. It should be a battle all across these 10 states for that very reason. And a final point of deception, and you've been very involved in this. You were counsel for Sandra Cano, who was the plaintiff in the Doe v. Bolton case that was the companion to Roe v. Wade. And that case had a lot to say about the definition of health, which I'd like you to remind our audience about, because in these amendments, we see the word health thrown around. Now, some of the amendment, you look at the language of these 10 amendments, some of them attempt to describe what they mean by health. Some of them don't define it at all, like the Florida amendment language doesn't define health at all. Again, from the legal perspective, if you've got an amendment that gets into the Constitution, uses the word health, and it's not specifically defined or not defined at all, or it's open for question, Allan, what's likely to happen in the light of how the courts have treated abortion over the years?
All right. The way they use this is to appeal to emotion that we all have because we want to help women. And what they say is, a woman can get an exception even to a ban on abortion if it's for her health. Or under these things, she said, she can get an abortion at any time for the health of the woman. Sounds very appealing, because when we think of health, if you're going to kill a child, it has to be a very serious health problem, like maybe the life of the mother. We all agree on that one. Sometimes maybe a major impairment of a bodily function. But no, that's not what health means in them. Because in a case called Doe v. Bolton, the Supreme Court of the United States created the health exception to the Roe v. Wade framework, actually, because at the time, Georgia had a therapeutic abortion statute, which said if you needed abortion for the health of the mother and 3 doctors agreed, you could get an abortion. Now, this was in the early days of abortion in America, even before Roe and Doe passed, but by the Supreme Court. And if you really wanted good medical care, wouldn't you think the opinion of 3 doctors would be better than 1 doctor? We all know sometimes if you have serious surgery, you ought to get second or third opinion. But the Supreme Court struck that down. And the misleading thing is they said, well, we all agree that psychological well-being is an aspect of health. Mental health is part of health. Well, yeah, some thought that sounds good. Well, then if a woman wouldn't be happy being a mother, then that's enough to get an abortion because happiness is part of well-being. So if a woman says, oh, I wouldn't want to be a mother, I'd be disturbed about it. Or no, I don't, I think it put a burden on my life. Well, then there you have it. Abortion on demand. All it takes is for the mother to want an abortion and an abortionist to do it for money. And that's been no problem to find those abortions. So that's what the court said. Most people don't think just psychological well-being, a general feeling of happiness is enough to get an abortion. And that's why that term is so deceptive. It makes you think about something serious, not just, well, I wouldn't be happy. I want to be a ballerina with my life, and I just want to go on doing what I want to do. That's not a good enough reason to kill a child, especially when every state has free self-haven laws that are not paid for. I mean, abortion is expensive. Safe haven is free. Surrender your baby within a certain period of time after birth or at the time of birth, and you don't have to pay for an abortion, kill a child, and suffer the devastating psychological consequences. Because I do want to say that the Supreme Court of the United States, in the Casey decision, upheld reasonable state regulations on the grounds that women can suffer devastating psychological consequences if they're not informed of the risks of abortion. And these constitutional amendments would strike down even informed consent because it might delay this process. And in Gonzalez, the U.S. Supreme Court also said, some women come to regret aborting the infant life they once created and sustained. Severe depression and loss of esteem can follow. So these state amendments do not protect women, and they kill a human child.
It's so important to understand how health has been used to open up the door to unlimited abortion. Again, people think that we're exaggerating here, and the amendments are deceptive because many of the language of these 10 amendments say, well, we're allowing abortion up to viability. But then they have the word or, up to viability, or at any time if the woman's health requires it. Health, as you just explained, is interpreted very broadly by the courts. Dovey Bolton even said it includes the woman's age. Oh, I'm too young to have an abortion. Oh, there you go. Health reason. Too young. Normal people don't think of health in terms of just your age. In fact, they tend to think the younger you are, the more healthy you tend to be, right? So it's so deceptive because they say, or anytime if her health depends on it. And then you have, and we're going to be discussing in another program with some of our medical experts, you have the language that says, if the health as determined by a healthcare provider. And then they don't even define healthcare provider. It's not necessarily an MD, it could be a physical therapist, or a counselor. So we're really in very dangerous territory here. And really the citizens of our country deserve honesty, transparency, specificity about what these amendments would lead to. And citizens should know this before they vote on these amendments. So thanks, Allan, for your legal insight into this. And thanks again for all that you do for the moms around the country who are wounded by abortion. We work together in that arena and look forward to working a lot more in the years to come. God bless you, and thanks for being on the program. So my gratitude to Allan Parker, and friends, my gratitude to all of you who are working in these various states to educate people about the language. Let me make one more point before we close. We are, with all 10 of these amendments, in Arizona, Colorado, Florida, Missouri, Montana, Maryland, Nebraska, Nevada, New York, and South Dakota. We are, for all 10 of these, on the no side. And when you're on the no side, time is on your side. What do I mean? What I mean is people, when they initially hear the language of these amendments, might think, gee, that sounds pretty good. I'm in favor of freedom, health, rights. But then when they understand the implications of the language of these amendments, like we have just traced with Allan's help, then they begin to have doubts and say, well, maybe I won't vote for this. In other words, the closer we get to Election Day, the more the support for these amendments will go down, because you and I, and many others with us, are working to educate people to understand that the language in these amendments is far more than it seems to be, and far more harmful than it seems to be. So please take the message of this episode, and again, the information you'll find at stateballotmeasures.org, study it, and spread it to as many others as you can. Thanks so much for watching this special series. Please spread it to others. We'll be back with more in the coming weeks. God bless you all.
Hello, this is Father David Begany. Like many priests, I receive a lot of encouragement and insights for my pro-life work from the Ministry of Priests for Life. This ministry speaks up for the unborn on television and radio, in conferences with pastors and with government leaders. But to accomplish all this work, the Priests for Life team relies on the donations of individuals like you who believe in this cause and want to help to save lives. May I ask you to support Priests for Life generously? Go today to prolifegift.org and give us as generous a gift as you can. Thank you in advance, and be assured of our daily prayers for you.